Good. I'm assuming you're probation.
Yes.
Very good. I'm going to ask the court not to cover the offense of outpatient, more of just the alcohol education. Okay. Didn't really seem like alcohol was the issue.
You may be seated. I didn't know that people were in here waiting. My apologies. Oh, they all came in at the same time together?
Yeah.
Who was with the Beagle? Who's with the Beagle?
There's a guy outside with a beagle laying on his duffel bag.
He's the cutest dog.
Beagles are good hunters. They really are good.
Mr. Grant, where are we starting, sir?
We could start with Ms. McKenzie. Mr. Stacy's ready to go. It sounds like.
Very good, Judge.
Give me 1 second to actually call the case. This is 24BL00160A. This is City of Belleville versus Amanda Kenzie.
And good morning, Judge. For the record, Brian Stacy, P33014, on behalf of Ms. McKenzie, and please state your name.
Amanda McKenzie.
Thank you, Ms. McKenzie. Today is the day and time scheduled for sentencing in this matter. Ms. McKenzie was charged with operating while intoxicated on April 21st, 2024 in the City of Belleville. She appeared before this court on May the 9th, 2024, and entered a plea of guilty to the reduced count of operating while visibly impaired. As is this court's policy with drinking and driving offenses, the matter was referred to the probation department. Mr. Grant interviewed Ms. McKenzie and sent a sentence recommendation up to the court. The court has had the opportunity to review that recommendation along with the police report in this matter. Mr. Stacy, is the report factually accurate?
Yes, Judge. I've gone over it with her last week over the phone and again this morning, and she tells me all the representations therein are accurate.
Thank you. Anything else you'd like to say on behalf of your client, sir?
Yes, Judge. She lives in the community, the court's jurisdiction. She's an office manager for a building company for the last 6 years. She supervises a lot of people. It's a job that entails a great deal of responsibility. This was a very unusual incident. She's never ever been in any type of trouble previously to this. Ask the court to take that into consideration. And Judge, even going over the report, I had a brief moment to speak with the probation officer, and I indicated to him I didn't think alcohol seemed to be her issue, and I thought the intensive outpatient program was probably a little excessive and not exactly what she needs. She does smoke marijuana on a regular basis, but she doesn't drink very often. So I would just ask the court for some type of alcohol education program in lieu of outpatient. And I believe she has something she'd like to say to you.
Thank you. Ms. McKenzie.
Yes, Your Honor. I just want to let the court know that I regret even thinking it was okay to get in a vehicle that day. It's not the kind of role model behavior I want to show my daughter at all. I'm ready to face whatever consequences and learn my lesson from this.
Thank you. Mr. Grant, was there anything you wanted to add?
No, Your Honor. As far as the alcohol education, that was an option there. Number 7, either the substance abuse treatment or the alcohol education. Either is fine.
Either is fine?
Yeah.
Thank you. Anything else, Mr. Stacy?
Nothing further, Judge.
Thank you. Again, this court has had the opportunity to review the recommendation from Tony Grant and will adopt his recommendation. Place Ms. McKenzie on 12 months of reporting probation. She will be responsible for the probation cost, oversight fees totaling $480. The court will also impose a fine of $300. There's cost of $100. There's $75 mandatory crime victim fee. There's $50 mandatory state cost, $20 fund fee. There is $150 in restitution due to the city of Belleville. Ms. McKenzie will complete 24 hours of community service at a nonprofit organization and provide documentation to probation. And ma'am, if you don't already have a relationship with a nonprofit to get your hours done, just reach out to the court's probation department. They maintain long lists of agencies that would be happy to have those 24 hours. Those 24 hours must be completed within the first 6 months of your probation. You will enroll in alcohol education within 30 days of today's date and follow all recommendations from that program and provide documentation to the probation department. You will not purchase, possess, consume any alcoholic beverages or non-prescription controlled or mood altering substances without this court's approval. And you will submit to random ETG testing a minimum of twice per month or as directed by probation. And I will issue a warning to you, Ms. McKenzie, if Mr. Grant reports to this court that you have tested positive for alcohol while you're on probation with this court, it could be viewed as a violation of the terms of your probation, and you could spend a period of time in jail. Do you understand?
Yes, Your Honor.
Thank you. And last but not least, ma'am, you will make regular equal monthly payments on the fines and costs that have been imposed in this matter. The court's collection department will be available to set a payment plan for you.
Thank you, Judge.
Additionally, Mr. Grant will be in contact with you. There will be forms that you will need to review and sign that will formally place you on probation. And Ms. McKenzie, the court's goal is that we don't see you again, that you're successful on probation, that you do not reoffend. So if there is any part of your probation that you're struggling with or you have questions about, reach out to Mr. Grant sooner rather than later. Anything else, Mr. Stacy?
Nothing further, Your Honor.
Thank you. Good luck to you, Ms. McKenzie. Have a good day.
Always a pleasure to see you, Judge.
Good to see you, sir. Okay, not a problem.
Thank you.
This is 2402780D. This is City of Romulus versus William Martin.
Good morning, Your Honor.
Good morning, Mr. Hadley.
Your Honor, Attorney Josh Hadley, attorney on behalf of the defendant, Mr. William Martin. Please state your name. William Martin.
Thank you. No relation.
Mike.
No,
Born
no
and
relation.
raised. We won't have to, we acknowledge no relation and there's no conflict of interest whatsoever.
Thank
Although
you.
he did, we reminisce, he lives in Ohio now, but is born and raised, so talking about what looks the same and what looks different around this area.
Okay. Today is the day and time set for sentencing in this matter. Mr. Martin was charged with operating while intoxicated in the city of Romulus on October 21st, 2023. He appeared before this court on April 4th, 2024, and entered a plea of guilty to the reduced count of operating while visibly impaired, as is this court's policy with drinking and driving offenses. The matter was referred to the court's probation department for interview and development of a sentence recommendation. The court has received and reviewed that recommendation along with Mr. Martin's probation intake sheet, his needs assessment, and the police report from, nope, not that, sorry. His needs assessment. Mr. Hadley, have you had the opportunity to review this information with Mr. Martin?
We did, Mr. Martin. I reviewed the report and recommendation. We have no additions, deletions, or corrections to make, Your Honor. We would in fact ask that the court adopt the recommendation at this time with a couple of minor tweaks that I think can be addressed between Mr. Martin and probation because he does live in Ohio, so we just need to work out logistics for the community service hours.
Okay. Any additional allocution, Mr. Hadley?
Your Honor, this individual who makes a living driving, this has been pretty devastating as a whole. Again, we don't use that to say anything other than the message has been received loud and clear. I think that the impact that this has already had in his life has reverberated pretty significantly, and he looks forward to complying with probation.
Thank you. Mr. Martin, anything you'd like to say on your own behalf, sir?
No, I'm just sorry. I should have never been went to Greektown that night. So.
Thank you, Mr. Martin. Again, the court has had the opportunity to review the pre-sentence report and the recommendation and will adopt that recommendation and place you on 12 months of reporting probation with the associated oversight fees of $480. The court will impose a fine of $300. There's cost of $100. There's $75 mandatory crime victims fee. There's $50 mandatory state costs. There's $20 fund fee. There's $150 of restitution due to the city of Romulus. There is 24 hours of community service to be completed at a nonprofit organization. I understand Mr. Hadley's concerned that you live in Ohio, so there are nonprofits there that I'm sure Mr. Grant would find acceptable.
Yeah.
Those 24 hours of community service must be completed within the first 6 months of your probationary period. You'll provide documentation of those hours to the probation department. You will enroll in substance abuse treatment or alcohol education within 30 days of today's date and follow all recommendations from that program and provide documentation to the probation department. Mr. Grant will assist you in making that connection as well. You will not purchase, possess, consume any alcoholic beverages during the pendency of this probation. You will not possess, consume, or purchase any non-prescription controlled or mood-altering substances. You will submit to random ETG testing a minimum of twice per month or as otherwise directed by the probation department. You will make regular monthly payments on the fines and costs that have been imposed by this court. And Mr. Martin, as I indicated in the previous case, this court's desires that you be successful on probation, which means if there's any issue that you have, any questions about what the court is requiring of you, you reach out to Mr. Grant sooner rather than later. If the court receives reports that you have failed to comply with any of these terms of probation, including testing positive for alcohol or non-prescription controlled substances, it could be viewed as a violation of the terms of your probation. Your probation could be violated and you could spend some time incarcerated. Do you understand?
Yes.
Is there anything else, Mr. Hadley?
No, Your Honor, thank you very much.
Anything else, Mr. Martin?
No.
Have a good afternoon, sir. I had the police report and I lost it. I had it last week because I read it because there are notes about it. This is 2402820D. This is City of Romulus versus Sean Labuda.
Good morning, Your Honor. MIDC Counsel, Attorney Josh Hadley, appearing on behalf of Mr. Sean Labuda. Mr. Labuda was pro per through this, but we went over the PSI together for today's sentencing purposes.
Thank you. Would you state your name for me, please?
Sean Labuda.
Thank you, sir. Today is the day and time scheduled for sentencing in this matter. Mr. Labuda was charged with operating with a blood alcohol content of 0.17 or more in the city of Romulus on January 24, 2024. He appeared before this court on April the 4th, 2024, and entered a plea of guilty to the reduced count of operating while intoxicated. As is this court's policy with drinking and driving offenses, the matter was referred to the court's probation department. Mr. Labuda was interviewed by Mr. Grant, who developed a sentence recommendation in this matter. The court has reviewed that recommendation along with Mr. Labuda's probation information sheet, his ACE questionnaire, his needs assessment, the police report from the incident, and his driving record and criminal history. Mr. Hadley, please understand that the court has concerns about the accident that happened as a result of Mr. Labuda's decision to operate a motor vehicle while intoxicated and damaging another vehicle. That being the extent of the concerns that the court will raise. Have you had the opportunity to review this information with Mr. Labuda?
I did. Mr. Labuda and I reviewed this. We have no factual corrections, deletions, additions to make. Your Honor, we did note about the two-car accident that you mentioned. There was a letter that was sent out regarding restitution. There has been no claim of restitution at this point. It sounds like they're handling that swiftly.
Understood. Mr. Labuda, is there anything you'd like to say on your own behalf, sir?
I would just like to apologize, Your Honor.
Thank you, sir.
And Your Honor, I know that I only had a brief moment to meet with this individual today, but after speaking with him and going over what this sentencing recommendation is, and what this could have looked like and could have meant, I do believe that he's sincere in his statements that he will comply with probation and will not be a repeat offender moving forward.
I appreciate that, Mr. Hadley. The court having had the opportunity to review the recommendation and hear the allocution of Mr. Hadley, the court will adopt the recommendation in its entirety, place Mr. Labuda on 12 months of reporting probation with the associated oversight fees of $480. Additionally, the court will impose a fine of $500. There's cost of $100. There's $75 mandatory crime victims fee. There's $50 mandatory state costs, $20 fund fee, $150 in restitution due to the city of Romulus, for a total of $1,375. The court will also order that Mr. Labuda complete 24 hours of community service that must be completed within the first 6 months of the probationary period. You will enroll in an alcohol education program within 30 days of today's date and follow all recommendations of that program and provide documentation to the probation department as requested. You will not purchase, possess, consume any alcoholic beverages during the pendency of this matter. You will submit to random ETG testing a minimum of twice per month or as otherwise directed by the probation department. As indicated previously, should this court receive reports from Mr. Grant that you're testing positive for alcohol, you could be viewed as a violation of the terms of your probation, and you could spend a period of time in the county jail. Do you understand, Mr. Labuda? Additionally, sir, you will make regular monthly payments on the fines and costs that have been imposed in this matter. The court's collection department will be able to help you set those payment plans. Mr. Grant will be in contact with you in the next day or two. There will be documents for you to review and sign that will place you formally on probation. And as I indicated to the two that appeared before you, the court's desires that you take something away from this probationary period, that you're successful on probation. If you need anything, I would ask that you reach out to Mr. Grant when you're struggling a little bit, or you have questions about what's expected of you versus failing to comply with the terms of probation and being back here for a violation hearing, okay? Anything else, Mr. Hadley?
No, Your Honor, thank you very much.
Thank you. Have a good day, Mr. Labuda. I know. I know. Two 40281 OD, City of Romulus versus Rachel Patton.
Good morning, Your Honor.
Good morning, Mr. Hadley.
I'm Josh Hadley, appearing on behalf of the defendant, Ms. Rachel Patton. Please state your name for the court today.
Rachel Patton.
Good morning, Ms. Patton. Today is the day and time scheduled for sentencing in this matter. Ms. Patton was charged with operating with a blood alcohol content of 0.17 or more on December 12, 2023, in the city of Romulus. She appeared before this court on April the 18th, 2024, and entered a plea of guilty to the reduced count of operating while visibly impaired. There was a driving while license suspended, revoked, or denied that was reduced to failing to display a valid license. The court has had the opportunity to review the sentence recommendation developed as a result of the plea that Ms. Patton entered, along with the police report that describes Ms. Patton's driving on the wrong side of the road with a blood alcohol content of 0.202. The court reviewed Ms. Patton's handwritten explanation of what happened on that night. Court reviewed her criminal history along with her driving record. Mr. Hadley, you've had the opportunity to review this information with your client.
I have, Your Honor. We went over this together before the sentence today. We have no corrections or additions to make.
Thank you. Any allocution on behalf of your client, sir?
Yes, Your Honor. Having a chance to speak with Ms. Patton about this matter, we went through the probation's recommendation. We would first ask that you adopt that. She's indicated that, again, looks forward to complying with probation, getting this community service done somewhere local, close to where she's at in Detroit. Understands again that this could have been a much, much more serious situation, and taking this with grace and looking forward to putting this behind her. As I indicated, notes that the issues with alcohol are something that will be addressed and is going to be absent moving forward.
Thank you. Ms. Patton, is there anything you'd like to say on your own behalf, ma'am?
Just, I can just apologize and just say that I regret, getting behind the wheel. Drinking, driving.
Thank you, ma'am. Of concern to the court is that there was an operating while intoxicated from the city of Detroit in 2009. And Mr. Grant's information to the court shows an active warrant from Michigan State Police.
We did talk about that, Your Honor. I think that understanding that the Oak Park outpost is going to be the right place for her to contact to get this warrant cleared up. And she has indicated to counsel and is now in court that she will absolutely be actively going to get that cleared up.
Thank you for that clarification, Mr. Hadley. If there's nothing else, the court will impose the following. Ms. Patton, the court will place you on 12 months of reporting probation with the associated oversight fees of $480. For the operating while visibly impaired, the court will impose a fine of $300. There's cost of $100. There's $75 mandatory crime victims fee. There's $50 mandatory state costs, $20 fund fee. For the no operator's license on person, the fine will be $100. There's cost of $100. There's $50 mandatory state costs. There's $20 fund fee, and there's restitution of $200 due to the city of Romulus. The court is ordering 24 hours of community service that must be completed within the first 6 months of your probation. If you don't have an organization that you're already affiliated with where you can get those community service hours completed, reach out to the court's probation department. They maintain files of agencies that would be happy to receive those hours. If you need to find someplace closer to you, just please review that with the probation department. You will be required to provide documentation that the hours have been completed. You will take care of and clear any existing warrants. Mr. Hadley has indicated that that is the Oak Park outpost, but you will do that within 30 days of today's date and provide documentation to the court's probation department that that warrant has in fact been addressed. You will enroll in substance abuse treatment within 30 days of today's date. Follow all recommendations from that program and provide documentation to Mr. Grant. You will not purchase, possess, consume any alcoholic beverages or non-prescription controlled or mood altering substances without the court's approval. You will submit to random ETG testing a minimum of twice per month or as otherwise directed by probation. You will make regular payments on the fines and costs that have been imposed in this matter. The court does note that your information sheet shows that you are unemployed. Have you since gained employment?
Yeah,
Okay.
I started, June 10th,
Wonderful. Where will you be working?
at SKLD Nursing, Home. So I just graduated from, nursing assistant school, so.
Congratulations.
Thank you.
And Ms. Patton, I know you've been sitting in the courtroom, so you've heard me say before, the court's desires that you are successful on probation and that you don't reoffend. And if there's anything that you need to be successful on probation, reach out to Mr. Grant sooner rather than later. If you have any questions about the expectations, reach out to him. If you're struggling with anything, reach out. It's a lot easier for Mr. Grant to provide support than for you to appear and explain why you have violated the terms of probation. Is there anything else, Mr. Hadley?
No, Your Honor. Thank
Miss,
you.
thank you. Ms. Patton and Mr. Grant will be in contact with you. There will be documents for you to review and execute that will formally place you on probation. It's okay. It will be okay, ma'am. Oh, Ms. Patton,
A little bit of a release.
I understand. Do you need Kleenex? Don't cry, ma'am. People will think I've been mean to you. But Ms. Patton, everything will be fine. Again, reach out to Mr. Grant if you need anything. Other than that, you have a wonderful afternoon and good luck on the new job, okay?
Thank you.
You're welcome.
This is your go-to office.
Well, see, she'll go out in the hallway and people will think I've done something.
No, I think you did. We all understand that feeling of just, okay.
I know,
Moment's come and now it's gone.
I understand.
And Your Honor, we're ready to, oh, I'm sorry.
No,
Yeah.
I was just,
I was looking to see how many I had left. I thought I only had one.
no, I'm just messing up Mr. Grant's files. I have the wrong paperwork stuck in the wrong file, but he'll figure that out downstairs.
I can't read your writing either, so I'll figure it all out.
That's why I'm talking slow, so you can roll back the tape, and if you have any questions, you keep them to yourself. Mr. Hadley,
Yes, Your Honor.
who do we have here?
Clarence Stewart, I'm covering on
You
behalf of, Mr. Jadal.
In my head, I'm thinking this is the first one that you asked.
No, that's my fault.
Nope, it's fine. I looked up and the name did not match the face, and so I was getting nervous for a minute. 2309450 OD, City of Romulus versus Clarence Stewart III. May I have your appearances, please?
Good morning, Your Honor. Attorney Josh Hadley, appearing on behalf of the defendant, Mr. Clarence Stewart III. Please state your name for the record. Clarence Stewart III.
Thank you. Today is the day and time scheduled for sentencing in this matter. On December 2nd, 2023, in the city of Romulus, Mr. Stewart was charged with operating while intoxicated in open intoxicant vehicles and driving while license suspended, revoked, or denied. He appeared before this court on April the 18th, 2024, and entered a plea of guilty to the reduced count of operating while visibly impaired. The open intoxicants in vehicles was dismissed, and there was a plea of guilty to the reduced count of no operator's license on person. As is this court's policy with drinking and driving offenses, the matter was referred to the court's probation department for interview and development of a sentence recommendation. The court has had the opportunity to review that recommendation along with the probation information sheet. Mr. Stewart's needs assessment, his driving record, his criminal history, and the police report from the Romulus Police Department. Mr. Hadley, have you had the opportunity to review this information with your client?
Yes, Mr. Stewart, and I had a chance to go over this today before sentencing. We had no factual corrections or deletions, additions to make.
Any allocutions on behalf of your client, sir?
Yes, Your Honor, Mr. Stewart, and I ran through again what the probation department's recommendation is. We would ask that you accept the recommendation, and he acknowledges the same, I don't want to be a broken record, but again, we've had a lot of the same conversations today. I mean, he understands that while this is a serious matter, it could have been much more serious. I would point to lack of any prior alcohol-related driving issues, again, to say that I don't see this as a first time somebody's gotten caught. It does appear to be, from my conversation and his representations, it's a bad night. Not something that would necessarily be in conforming with his normal behaviors. I think he's going to be a model probationer and looks forward to putting this behind him.
Thank you, Mr. Hadley. Mr. Stewart, is there anything you'd like to say on your own behalf, sir?
Yes, I do apologize for the situation. It's not something I do all the time. I've had a lot of time to reflect on it. And I do understand the severity of this. I don't want to be a role model like this to my son. And so true sorry for this situation.
Thank you, Mr. Stewart. Mr. Hadley, this court's concern is that the information submitted by Mr. Grant indicates there is another operating while intoxicated charge that may be pending with an offense date of February 11, 2024, which is 2 months after the incident that he's here for this morning and 2 months before he was arraigned in this matter. Am I reading the wrong information sheet, Mr. Grant?
No, you're correct.
Your Honor, well, I guess we're a little swinging in the dark on it as to we're not really sure as to what jurisdiction or what offenses would be related.
It indicates Romulus with an offense date of February 11, 2024. Was there another, did you have another involvement with the Romulus police after this December incident, Mr. Stewart? Okay.
I do see that now, Your Honor, and I guess again, with that being understood, that one's not been resolved, so again, I would say to rest on this Fifth Amendment right at this point in time and not make any statements about that other case, but we will acknowledge that it is out there, it is of concern, and I do think that that's part of the bolt of lightning that seemed to have hit this time, where he's like, wow, we've got a situation here, so.
I appreciate it, Mr. Hadley, and I raise it because it does not look like the case has even started with this court. I don't see that charges have even been filed, but it's out there. And when this court does adopt Mr. Grant's recommendation, the concern is that if this second case becomes, well, the second interaction becomes a case,
It could
that it will impact Mr. Stewart going forward. So if that's something you follow up with him or he follows up with retained counsel or whatever, I just don't want it out there unattended to.
Absolutely understood, Your Honor. Thank you for pointing that out, because you're right. The register of actions, there isn't one yet for this online. So I think that if there is a silver lining to this, it's that we're going to be dealing with the same court system and the same probation department. And we would all hope that we can work towards the right treatment and resolution for this individual if there is a finding of guilt in the second case.
Thank you. Again, the court having had the opportunity to review the information provided by the probation department, the court will place Mr. Stewart on 12 months of reporting probation with the associated oversight fees of $480. For the operating while visibly impaired, the court will impose a fine of $300. There's cost of $100. There's $75 mandatory crime victims fee. There is $150 of restitution due to the city of Romulus. There is a $50 show cause fee for failing to appear, a $50 bench warrant fee for a second failure to appear, $50 mandatory state costs, $20 fund fee, and $15 administrative fee. For the no operator's license on person, there is a fine of $100. There's cost of $100. There's $50 mandatory state costs and $20 fund fee. The total of the fines and costs in this matter will be $1,560. Mr. Stewart, the court is also ordering you to complete 24 hours of community service within the first 6 months of your probationary period. If you do not have an organization that you're already affiliated with where you may complete those hours, you will reach out to the court's probation department They maintain files of agencies that will be happy to receive those hours. Additionally, you will enroll in substance abuse treatment within 30 days of today's date. You will follow all recommendations from that program and provide documentation to the court's probation department. You will not purchase, possess, consume any alcoholic beverages or non-prescription or controlled substances without this court's approval. You will submit to random ETG testing a minimum of twice per month or as otherwise directed by the court's probation department. You will make regular monthly payments on the fines and costs that have been imposed. The court's collection department is able to assist you in setting a payment plan if you need one. Additionally, Mr. Stewart, the court is asking that if you receive information that this February 2024 interaction with the Romulus Police Department becomes an actual case, that you reach out and advise Mr. Grant so that we can work with you to make sure that these matters are resolved and travel together as much as possible so that so that you're not double assessed, I think, for lack of a better word. But as indicated previously, the court's desire is for you to be successful on probation. That means if there is anything you're struggling with or any questions you have about any of the terms of your probation, that you reach out to Mr. Grant sooner rather than later. There will be some documents for you to review and sign. Mr. Grant will be in contact with you to make sure that those documents are completed. Is there anything else, Mr. Hadley?
No, there isn't, Your Honor.
Anything else, Mr. Stewart?
No, thank you.
You have a good day and good luck to you, okay? Good morning, Mr. Jadala.
Good morning, and thank you, Josh, for the assist. Your Honor, I have a Christopher Walker. I'm not sure, I didn't tell Mr. Hadley about that. There was no PSI in the matter. It was just to see if the victim sent a letter in.
We have not seen, let me go check in the hallway real quick.
I have not seen Mr. Walker this morning. There were no responses to any of the victim impact, requests for victim impact statements. So, Mr. Jadala, I would say that it was scheduled, these cases were scheduled at 8:30. It's now 9:20 by this court's clock. These are the cases identified as 230891, 230892, 230894, and 230931. These are all State of Michigan versus Christian Walker. The court did receive a report from Mr. Grant that indicates that Mr. Walker is identified as being homeless with no foreign address, that contact was made with Mr. Walker's mother at his last known address, and there was an indication that the mother, would provide the information to Mr. Walker. But as of May 29, 2024, Mr. Walker's location was unknown.
And Your Honor, I will remind the court that at the time we took the original plea, he was incarcerated at Lake City, and he remained incarcerated for quite some time. And the last sentencing date, Your Honor, the mother did call the court to say that he was in the hospital, and that's why we adjourned it to this day. And the number and the contact information I have for both the mother and Mr. Walker they were unresponsive. So I don't know if he's incarcerated or still in the hospital. So I don't have any further things to report to the court. I just wanted to make sure that we were just all on the same page, because the court remembers this was a plea, set aside a plea, and then a replea due to some miscommunication between me and the state prosecutor.
Thank you, Mr. Jadala. I do remember this case. And unfortunately, when someone does not have a stable address and there's no one to relay information to him, the court's kind of stymied with how to proceed. But Mr. Walker's case is being assaultive in nature over a period of approximately 2 weeks. And at the time the plea was taken, Mr. Walker indicated that the persons he assaulted were unknown to him. The court has concerns about his reoffending and his being a threat to the community. Based on those
And Your Honor,
factors, the court will.
If I could ask briefly, Your Honor, from what I recall, the sentencing, I don't know if we asked for a PSI. I believe we set sentencing just for victim impact statements and not necessarily for a PSI. I think the court was considering time served because he was incarcerated for quite some time after the plea. That's how I recall it. I could be mistaken, but I'm not sure if a PSI was requested.
The court did not order a PSI, and the court was considering crafting a sentence that would assess Mr. Walker's situation and
Okay.
determine if the probation department could be supportive in any way. But the fact that he came out of MDOC, got into some kind of interaction that resulted in him being hospitalized and now being homeless, the court just had concerns. Mr. Walker's demeanor at the time that he pled to assaulting what were essentially strangers just gave the court's concern. So not necessarily credit for time served and not needing a PSI, but laying eyes on and having conversation with his status right now. A lot could have
Understood.
happened between November of 23 and now. But because he has not appeared this morning, the court will issue warrants in these matters, 5,000, 10%. Should he encounter the police department and is able to appear and be heard on these matters, we could talk about time served. But for right now, I just want to know where he is and what he's doing. Make sure that there has been no other interaction with the police departments between the time he last appeared here in April and now.
Understood, Judge. Thank you very much.
Anything else, Mr. Jadala?
Nothing further, Judge. Thank you.
Have a good day, sir. That was my note to follow up with you about, to see if he had shown up anywhere else, because I vaguely remember what happened to cause his hospitalization. Just wanted to make sure he wasn't on somebody else's radar.
I did do a search. He wasn't locked up when I sent that report.
Okay, thank you. This is 23HR 13900. This is Huron Township versus Rachel Hoover.
Good morning, Your Honor. Attorney Josh Hadley, standing in for MIDC counsel, Mr. Dan Batar. Is it Hubbard? Hoovers. No, I got it wrong. All right.
50-50 shot, right?
You can state your name, please.
Rachel Lubeck.
Thank you. Today is the day and time scheduled for sentencing in this matter. Ms. Hoover was charged with operating with a blood alcohol content of 0.17 or more on December 16, 2023 in Huron Township. She appeared before this court on March the 28th and entered a plea of guilty to the reduced count of operating while visibly impaired, as is this court's policy with drinking and driving offenses. The matter was referred to the court's probation department for interview and development of a sentence recommendation. The court has had the opportunity to review that recommendation along with Ms. Hoover's probation information sheet, her needs assessment, the police department's report from that night, her driving record, her criminal history. And Ms. Hoover, before Mr. Hadley makes his first statement in this matter, the court did have concerns about the fact that you were reporting a history of cocaine, acid, and Molly use, that at the date of the offense that you had a blood alcohol content of 0.28 or more. The court does understand that there were some aggravating and extenuating circumstances regarding yourself and the other things that were occurring on that December 16, 2023 date, and we'll take that into consideration. Mr. Hadley.
Your Honor, I have had a chance, as well as Mr. Batar, to review the PSI. As far as one factual dispute, there does seem to be a statement attributed to Ms. Hoover that basically it's attributing, stating that she made a statement to the probation department, says, I don't have a problem. She's stating that she never said, I don't have a problem. In fact, I think because we've kind of talked through it, she wouldn't say that. That's not her position as it relates to that. Otherwise, no other corrections, additions, deletions to make. That was the one point that we did see.
Thank you. Any additional allocation, Mr. Hadley?
Absolutely, Your Honor. In this instance, unfortunately, we have a unique set of factual circumstances with this defendant. one of the reasons I asked this court, and I thank this court for passing the matter, is that this defendant is currently undergoing or has a cancer diagnosis. She is fighting pancreatic cancer. Is under the care of her oncologist and team of doctors, working obviously to fight this. I come with an ask that isn't unfounded in statute, Your Honor. MCL 769.5, as this court's aware, subparagraph 3 states that there is a presumption for non-serious misdemeanors, which an OWI that doesn't cause property damage under 780.811, as this was all amended again in 2021. As I may say that wrong, maybe in 2022. Either way, recently amended statutes addressing these probationary matters. Your Honor, we know that it's fully within your discretion to rebut that presumption, as quite often is the district court's practices in OWI cases. There's a number of factors that the court can cite to for why probation would be appropriate in an OWI case. I just bring all this up to remind the court that it is the starting place legally right now for this offense, that we don't come with just a, please give us this because of her circumstances. But what we are asking for, Your Honor, is the court to fashion a unique sentence in this matter where her substance abuse can be addressed through therapy and counseling, but yet she's sentenced to a non-probation term where it will be fines and costs. The court can still accomplish this without probation oversight, where simply by not completing any of the required outpatient counseling that she was to do, she could still be show cause and will be under the court's contempt powers for not complying with, again, going out and seeking this counseling, this therapy. The reason really we're asking for the non-probation sentence is really the diagnosis. The obstacles and a lot of what she's dealing with in life right now makes a schedule and makes her day-to-day very unpredictable. And I'm not wishing that things go one way or the other, but I don't want to see a pattern of show causes and violations of probation that this court is constantly dealing with, when really it's not about her non-compliance or continued alcohol use. It would be about missed dates and missed this and missed that. So that's, after speaking with Mr. Bitar, with Ms. Hoover, we understand the nature of our ask. We understand the gravity of the ask, but we do think in this circumstance that it's something that would be fair for this court to consider. We would ask you to do that and take an unusual step in fashioning a non-probationary sentence.
Did you have this or a similar conversation with Mr. Grant this morning?
I have not had a chance to, and I do apologize. I kind of jumped in and wasn't sure whose hearings I was going to be covering. If you'd like to pass the matter for a moment and let us speak, I'm more than happy to, because I am kind of dropping this on him from out of left field as well.
I understand, and I would ask that we pass the matter so that you may speak with him, because my note specifically next to reviewing the file is check the status of Ms. Hoover's health and determine how we best accomplish what our job is in this matter.
Absolutely.
So if you would like to, we'll pass the matter. You and Mr. Grant can retire to one of the council offices, and when you're ready, let Officer Brooks know. I'm not going far, just want you to have a conversation.
A couple of the VOPs, if you'd like, I can meet with them and we can kind of reconvene and just do a second act for today.
Sounds good. If Ms. Hoover, you understand what we're doing right now? Okay. So when you're ready, Mr. Hadley, just let us know. We'll come right back out.
Absolutely, Your Honor. Thank you very much.
Thank you.
I apologize.
No worries. No, appreciate you, sir. I'm coming, I'm sorry.
Oh, she did, it was because that was the day where they didn't have anything for, no, what was that?
One shift, not so.
Okay.
It's a problem, it's a problem.
Yeah.
That's the first time I've heard that name. Shame.
This is a recall of 3 HR 13900OD, Huron Township versus Hoover.
Thank you, Your Honor. Attorney Josh Hadley, and staying to my right, Ms. Hoover. Your Honor, thank you for passing this. We had an opportunity to speak with Mr. Grant with the probation department, and I believe that we tailored, if this court would be willing, a proposed sentence.
Yes, Mr. Hadley.
All right, I guess I didn't ask the length. I think it was gonna be a 12-month period that we're talking. Your Honor, we would be asking that the court adopts the recommendation, 12-month period of probation. But the probation meetings with Mr. Grant will be done via Zoom. So the individual will not need to come into court. They've agreed to waive the community service imposition of 24 hours if this court would be so willing to accommodate. As to the substance abuse, it would be the 2 times
All recommendations.
all recommendations that would come from the substance abuse. And I believe it would, again, defined within 30 days to get enrolled in substance abuse counseling. And again, if telehealth is an option for her, Mr. Grant has no issue with that either. We had a conversation off the record about what to do in the instance of medical emergencies arising. Ms. Hoover's been fully apprised of what steps to take if something comes up, unfortunately, that would cause her to miss dates or not be able to comply with any of the probation department's orders.
Thank you. Ms. Hoover, is there anything you'd like to say on your own behalf?
Thank you for working with me. I appreciate it. My health is not the best and I just need a little help with everything, you know. I want to accept the consequences and do what I need to do to get past this, so.
Thank you, ma'am. Based on those comments, the court will adopt the recommendation of Mr. Grant insofar as Ms. Hoover would be placed on 12 months of reporting probation with the associated oversight fees of $480. Additionally, the court will impose a fine of $300. There's cost of $100. There's $75 mandatory crime victims fee. There's $50 mandatory state cost, $20 fund fee, $241 in restitution to Huron Township. That's a total of $1,266. Court is waiving the community service requirement, will require Mrs. Hoover to enroll in substance abuse treatment within 30 days of today's date, follow all recommendations from that program, and provide documentation to the probation department as directed. You will not purchase, possess, consume any alcoholic beverages or non-prescription controlled or mood-altering substances without the court's approval with random ETG testing a minimum of twice per month or is otherwise directed by the court's probation department. You will make regular monthly payments on the fines and costs that have been imposed by this court. And Ms. Hoover, because the court does in fact want you to be successful in probation, the court will allow as much engagement with this court to be virtual as possible. And should you have a change in your circumstance, would ask that you reach out to Mr. Grant to advise him of that, so the court might have an internal conversation about the need to adjust your probation or make any alterations to the terms and conditions of that probation. Mr. Grant will be in contact with you because there will be documents for you to review that will place you formally on probation. Was there anything else, Mr. Hadley?
No, Your Honor, that covers it, and thank you for giving us a moment to work with the probation department. My apologies to them for kind of dropping that without much notice.
Thank you. Ma'am, good luck to you. If there's anything that we can do from, as relates to this matter, please reach out to Mr. Grant. You're welcome. Have a good day.
Yep.
230962 SM. This is State of Michigan versus Jody McWhorter.
Good morning, Your Honor. Attorney Josh Adley, appearing on behalf of defendant Jody McWhorter, who's coming to the podium. Please state your name.
Jody McWhorter.
Thank you.
Just date and time for review hearing, I believe.
It is. Ms. McWhorter had tested positive for alcohol. And the court just wanted to make sure that this was an anomaly and that she had then thereafter been complying with the terms of her probation. Where do we stand this morning, Mr. Hadley?
Your Honor, we'll leave it to the court's discretion how to move forward in the probation departments. We don't contest the test, a positive test. It would state that it's our understanding that the probationer has made positive steps forward and is doing that.
Thank you. Mr. Grant?
She has, Your Honor. She had a slip up that she admitted to me. She's owned that slip up, but ultimately she was with GrowthWorks. I've got documentation there. She's completed her community service. Her tests moving forward have all been negative. So I ask that you just continue moving in the right direction and place her back on probation.
Thank you. Ms. McWhorter, was there anything you wanted to say, ma'am?
No, Your Honor.
Thank you. You were placed on 12 months of probation on January 17, 2024. We did have the conversation back on April the 6th when you were here with Ms. Patton regarding your plea of guilty to the alcohol, the positive alcohol. The court at this time will deem this review to be complete. Will continue you on in probation. Is there anything else, Mr. Hadley?
No, Your Honor.
Anything else, Mr. Grant?
No, Your Honor.
Thank you. Ms. McWhorter, good luck to you. Have a good afternoon.
Thank you, you as well.
Thank you.
I'm ready to go on Anthony Funch. Anthony, I said that correct?
Yeah.
Great.
23SU01239 AOD. This is Sumter Township versus Anthony Funch. Your appearances, please.
Morning, Your Honor. Attorney Josh Adley, appearing on behalf of the defendant, Mr. Anthony Funch. Please state your name for the record. Anthony Funch.
Thank you, sir. You appeared before this court on March the 4th, 2024. For sentencing. The court received a report from the court's probation department that indicated that you tested positive for opiates on April the 12th, 2024. You failed to report for monthly reporting on May 1st, 2024, and the subsequent rescheduled dates of May the 8th and May the 15th. Although you have paid all your fines and costs, you have failed to provide updated documentation regarding your alcohol education class. You failed to provide any documentation for the community service. Your testing positive for opiates is in direct contradiction of this court's order that you not purchase, possess, consume any alcoholic beverages or controlled non-prescription drugs during dependency of the probation. Mr. Hadley, you've had an opportunity to discuss these allegations with Mr. Funch.
I have, Your Honor. As to the allegations, I'd like to bifurcate the positive test from the failed to reports. We will be pleading guilty to the violation probations of failing to report on those 3 May dates. As it relates to the positive test for opioids on April 12th, we would plead not guilty to that, Your Honor. Contesting that he hasn't consumed any opioids. He has stated that he is on a prescription drug, sertraline. Am I saying?
I think that's right.
We believe that after doing my quick Google MD research, again, that there is no history of opioid use with this individual. It seemed kind of out of character from anything that we would have seen, that kind of Breaking Bad to an opioid use. I believe, and we would hope that the court would agree that it's much more likely that this prescribed substance, that it does sort of seem to kind of be in that end of the pharmaceutical spectrum, would be where this positive test came from. I would encourage him to speak with his doctor to make sure that that, again, is accurate. But again, the defendant's position is he's not consumed or used any opioids.
Thank you, Mr. Hadley. The court's concern then would be, Mr. Funch, after you receive notice of the need to appear here this morning, it's dated from this court on May the 15th. Have you provided Mr. Grant or the court's probation department with proof that you are on a prescribed medication that may cause a?
No, I didn't.
Okay, do you have that information?
Yeah, I do have a picture of it. He did present to counsel during our meeting today, Your Honor. I'm happy to approach to Mr. Grant now if you'd like, or we can go over it after. But he did present me with a photo of the prescription bottle.
I had the bottle in the car, I just didn't want to bring it in here, I didn't know how.
Which that's the best way. Don't
Yeah.
Understood, sir.
That's always good.
Mr. Grant?
The biggest issue I have is with Mr. Funch is his lack of communication. He doesn't respond to anything. The drug test, it said that he admitted to the, I believe it's on-site he's testing with, that he took opiates, and he would explain to his probation officer. This is the first time I've had a chance to talk to Mr. Funch because he doesn't report to his probation officer, and that's why he's here today.
And Your Honor, Mr. Funch, in discussion with counsel, has, I don't think he's disputing that. He has stated, because we discussed what was the basis for these missed tests, what happened, what's going on. And he does admit that he has dropped the ball, using idioms and phrases, but he understands that he needs to do better, and does admit that there was some mistakes and he has failed to fully communicate with Mr. Grant. Not making excuses, but to provide a little bit of context. He has had some transportation issues, but that doesn't negate reaching out and calling Mr. Grant. We've discussed that sticking your head in the sand when stuff's not going right is certainly not the approach, especially with this court, who court and probation department, who has indicated they'll work with you reasonably. So he's been instructed and understands that you've got to do your end of it. You've got to, it's not a meet in the middle. It's you go to them when you need help. So with all of that, Your Honor, again, it's not an excuse, just an explanation. And we would ask that the court consider that and give this individual, if the probation department's going to grant it, another opportunity at probation.
Mr. Grant?
I am asking that we add an additional 8 hours of community service for Mr. Funch and place him back on probation, and a review date 30 days out, which would put us July 8th, I believe.
I don't have the schedule, Mr. Grant.
Yeah, it is. It's the 8th.
Mr. Funch, what the court will do is adjourn today's hearing to July the 8th, 2024. The court has accepted the plea of guilty for failing to report. Mr. Hadley asked that it be bifurcated. And for your plea of guilty on that issue, the court will add an additional 8 hours of community service. As for your contesting the positive test for opioids, the court will order that you produce not a picture, but an actual something from the doctor that confirms that you have been prescribed by a medical professional a drug that may cause this positive testing. You will provide that documentation to Mr. Grant within the next 14 days. Let's say all prescribed medications within the next 14 days. so that Mr. Grant will have the opportunity to evaluate the documentation that you provide to him between now and the time we reappear on July 8th at 9:30 a.m. And going forward, Mr. Funch, I understand looking at your date of birth in this file that sticking the head in the sand, as Mr. Hadley said, might be a way of coping with the enormity of the situation. But should this court receive reports that you have continued to fail to report, tested positive for things that you should not have in your system, either because they're not prescribed by a medical professional or alcohol because you're still not old enough to legally drink in the state of Michigan. If you continue in failing to provide documentation for your alcohol education or fail to complete any of the community service, the court will likely view that as a violation of the terms of your probation, and you will face a period of incarceration in the Wayne County Jail. Do you understand?
Yes.
Anything else, Mr. Hadley?
No, we just thank the court for the grace today and give this individual another chance. Thank you.
Anything else, Mr. Grant?
No.
Thank you. You have a good day, sir, and don't forget to follow up with Mr. Grant. In 2402690M, the state of Michigan, nope, not state of Michigan, sorry, City of Romulus versus Daniel Schneider. This violation hearing was scheduled at 9:30. It is now 10 a.m. by this court's clock. Daniel Schneider.
We're cooling the gallery now, but there has been no one by that name who has checked in.
Mr. Snyder appeared in this court on April the 4th, 2024, and entered a plea of guilty to malicious destruction of property. He failed to return the paperwork requested by the probation department. There is an indication from Mr. Grant of the court's probation department that the defendant is currently homeless and there is no way to get in contact with him. Correspondence sent to the address in the court file was returned to sender. Mr. Grant was in contact with Mr. Schneider's mother, who indicates that she has no way to reach him and does not know where he's staying. Mr. Grant, any update or information?
Nothing, Your Honor.
During Mr. Schneider's appearance on April the 4th, 2024, he was advised that the court's probation department will be in contact with him through the phone number, email address, and physical address he provided. Mr. Schneider did appear for that hearing in the court's Zoom room. He has failed to appear this morning. The court will issue a bench warrant, 5,010%. If Mr. Schneider either presents himself to Mr. Grant or comes in contact with law enforcement and has an explanation for his failure to appear this morning, we'll address the matter at that time. But for right now, he is deemed as being in violation of this court's order. These are 21 HR 11287 A and B. These are Huron Township versus Damian Neal. These were add-on files. It appears that the report from Shannon indicates that the defendant appeared on June the 6th, 2022, and the case was adjourned for 30 days for Mr. Neal to become compliant. And he failed to appear on July 15th, 2022 for the show cause hearing, and a bench warrant was entered. He was originally ordered to serve 48 hours of community service at a nonprofit with documentation to probation, provide documentation of substance abuse treatment, and he was ordered not to purchase, possess, consume alcoholic beverages or controlled substances. Mr. Neal failed to provide documentation as required, failed to maintain a payment plan, and currently owes the court $1,736.20 in these matters. Mr. Neal subsequently had a warrant from the 35th District Court, which is Plymouth Canton, for failing to appear. He has a new operating while impaired from May the 19th, 2022 through the 33rd District Court, which is Woodhaven. a new operating while intoxicated on April the 20th, 2024, out of the 36th District Court in the city of Detroit. He appeared before this court with Al Hammond on May the 29th, 2024, was arraigned on the outstanding warrant, placed on $5,000 personal bond, and was ordered to appear here this morning at 9:30, it being now 10:05 by this court's clock. Defendant having failed to appear, these files are still showing as being in warrant status. The court will leave it as such.
Your Honor,
Sir,
I looked this morning, it was not in warrant status any longer, so I don't know if you made a opinion. Okay. Either way, I'll make sure. All right.
if he's not, he should be. Let me look. Maybe Al just forgot to recall the warrant. But from this court's perspective, it is a drinking and driving offense and a driving without cycle endorsement that is now approaching 3 years since the offense date. If that warrant was, let me look back here. The warrant was canceled, just not removed from the file, but the court will indicate that the file should be in warrant status, and as much as the defendant has failed to appear, although directed to do so less than a week ago by Al Hammond. That completes this court's docket for the day. We stand adjourned. Give me 1 second.